certain disabilities, say at least locomotive disabilities, can easily be accommodated in these nature of jobs. They are not jobs which are going to get affected because the nature of performance is a equated job. Somebody else with a different kind of disability may not be able to do so. But a person with certainly a locomotive disability can go into these areas of expanding jobs. Now, how do we rope in the sectors which are emerging and upcoming sectors and make them as part of this growth process? Now, can we do it with the Act, or do we do it with some kind of social concepts emerging and roping them in the process? I would say that it's not something ultimately which can only be done by amendments to the Act to take care of that position, but it has to be done with getting these areas seriously involved by the NGOs and the other organizations, so that they also may provide an X percentage, an unwritten X percentage, following the parameters which are given in the Act, in their employment schemes. That would be my first suggestion, where I would say this would be helpful. Now, as an illustration in a different line, I am given to understand that in the year 1999, the UGC itself, which is a government body, had issued a circular stating that it may not be possibly in the interest or to employ blind lecturers. There would be a problem. Now, Nalsar, which is the University of Law, has today employed a blind candidate as one of its lecturers. Now, look at the impact which this kind of a thing makes. It's not an issue of an isolation of one lecturer coming in to help. It's an issue of the overall impact that such a person can do a particular task like this. If we get into it and a particular person is doing a task of this kind, I'm sure it would be a beginning of getting people with disabilities into such fields where there is earlier a sense of a negativism, if I may say so, or a perceived inability of people with those disabilities to perform on those fields. I'm skipping over some of the issues because of time constraints and some of the discussion which has taken place, and I would like to come to some of the issues in the judgments which have been discussed and how the courts have perceived these issues. One of the examples, and I would like to take that example first, of how, though it is of course at a high level of employment, which took place in case of a person perceived who wanted to go into the civil services. The man applied for sitting an examination. He qualified, and he wanted to improve his performance. They said, let me try again as is permissible. By that time, when his medical was done, they said, look, you have certain vision disabilities, not blindness, but vision disabilities. And therefore, you cannot be taken into the civil services. You have no reservation, as provided in the Act. Interestingly, no exemption was made. There's no exemption under the Act was made. So he says, let me be taken as a person with disability. The stand taken is that we can't take you with a person with disability. And importantly, he is a man qualifying on merits. He is not a man who is seeking a reservation here. He sits again for exam. He says, now please consider the disability. He says, even that category we cannot give you a benefit. So neither will you consider a person under the general category, nor will you willing to consider that person with disability to give a reservation to that person. He, of course, approached the court where I had the opportunity to hear him, and I discussed some of the facts and figures which came to light, and to that extent the Commissioner of Disabilities was issued notice to render assistance, because ultimately we found that there may be facts and figures available with them which are not available. And what we found was that repeatedly different committees had been formed to locate in pursuance to the directions of the Apex Court categories of jobs which could be performed with persons with disability. At each stage a survey is made and it is found that, say, in X person, first emphasis is, let us look to only category C and D jobs. Let us not look to the higher jobs. Why? Let us try to meet the formality of this reservation to the extent possible. But let us try to keep out of the higher echelons of the job profile which is there. How in an administrative job where a person has to do a desk job, a person with a disability is incompetent, nobody goes into it. Even thereafter, when jobs are, some category A or category B jobs are shortlisted, a couple of years pass without any formalization. And then another committee is formed to look into the whole aspect once over again, to see now what was the problem and how it can be implemented. And here we are dealing with a candidate only of substandard vision, which is an issue. The figures which came to light when this matter was looked into, we found that even earlier the Disability Commission itself had looked into as on a complaint of another candidate. In pursuance to certain direction of the Disability Commission, matter was looked into, but all that had happened was that one committee was superseded by another committee to look into it. The original complaint, one gentleman by the name of Umesh Puranik, who really, though he started it, the benefit could not flow to him fully, wanted to get into the examination and applied. In 2003 itself, the Commission itself disposed of the matter. The Commissioner looked into it. And when it was put to him that why can't you appear, the UPSC, which is the controlling body which conducts the examination, said that, well, we have nothing to do with it, we are only a exam holding body. So you look to the Department of Personnel and Training of the Government of India, which will then decide as to where the reservation is. The Narasimhan Committee was set up in earlier in 1996, which was also with a job to look and find out how many of these reservations can be made and what can be done. And particular kinds of Group A jobs were looked into and shortlisted. It was found that there were certain recruiting ministries like in Department of Telecommunications, Ministry of Defence, the Railway Board. You have services like Indian Railway Account Service. There will be particular nature of services where the field job is less. So it would be more convenient for somebody with locomotive disability or other nature of disabilities to be able to perform those tasks. Yet, there was hardly any appointment which was taking place in this process, even to the effect that it was not being even put to public or notice that such a jobs have been identified and something had to be done to fill up the jobs. The UPSC did not know that such a job had to be filled in within these parameters. Ultimately, in 2003, they decided to set up another committee, an expert committee to review category A, B, C, D jobs once again. Now, these are only examples of how it was done. Well, he was fortunate that at least the government accepted the judgment, I thought, at some stage of time, despite that he was appointed and it was a battle for him. This is an example of how even at any level of echelon this is to be done. Now, here was a man who was himself in service, who was able to come to court to agitate his rights. What happened, as it is said, that an issue of disability is interlinked with people who have economic disabilities also and who are not able to approach forums of so easily as a man here who was able to do so. How do we look to their requirements in this process? Now, some of the other judgments which my focus has been, I'm trying to see how, since I was part of the Delhi court, how the approach of the Delhi court has been on issues of this nature, because more than one matter has come up in different ramifications. Delhi, we have the Delhi Development Authority as the authority which develops accommodation. Is there sensitivity to the issue of giving some reservation for persons with disability? If such a thing is done, is there a requirement where you have a multi-storied construction to see that you have some priority given to the person with disability to give at the lower floors something as basic as ground floor. Interestingly, it was found that if some people went under the special privilege categories, and if somebody was able to do so, they were getting it. But yet, people with disabilities who were wanting it on that basis, that please give us a priority on a ground floor location, or please give us where it is easily accessible to us, were not finding. And there have been litigations in court where the High Court has had to issue a mandamus saying that such benefit should be given. Change the category of the person. Change him into a flat which is available at the ground floor level. On various issues, one of the judgments which I would like to bring to notice was in Raman Khanna's case by the Delhi High Court. And the court had opined that it was impermissible for an institution to introduce conditions which would have the consequences of defeating statutory provisions contained in the welfare legislation. Now, what was the problem here? You have the 40% disability basic rights area which was there. The Medical Council of India stipulated that persons with 50 to 70% disability were entitled to the benefit of statutory reservation for physically disabled. Now, here is something which Brother Naski has raised, of reservation within reservation. Can it be permissible? This is again a debate which would arise within this parameter. They said, no, you can't do so. Now, can you do so? Then how do you do so? Legislature in its wisdom has set 40% as a benchmark which has to be taken. Once that benchmark is crossed, can we have without legislation a system by court intervention of saying that you will create categories of 70 to 80, 80 to 90, 90 to 100? How will you do so? How does it work backward in percentage terms? Suppose there's a difference of say 1% and you go to a different category. How will you, in job profile, how are you going to implement it? So, on the issue which was mentioned, here was a different standard point of view taken by the High Court, saying, no, you can't do so. The legislation is what will have to do this. Then we have the judgment of the High Court of the Division Bench dealing with the National Federation of Blind, dealing with the pertaining to schooling and providing free education to children. This is linked with the first aspect. If you say the base is there, how do you equip the people with disability in a better fashion to able to come up to a situation where they can occupy posts of higher echelons? Unless the education is there will be an innate restriction in their ability to join different fields of work. Ultimately, you're looking to an education, you're looking to employment, you're looking to a life with dignity. That life with dignity will come with a certain level of employment. That employment after a stage cannot come unless there is a level of education which has been attained by them. So, while considering this, it said that till the age of 18, when you're talking under Section 26 of the Act, it does not lay down a ceiling figure. And it is the duty of the state to provide education to children with disability till the age of 18. Now, this is again a judicial intervention, is what I would call it, or innovation, which is arising in this field. It was also said that financial constraint should not be a reason not to give it. This should not be a parameter. Now, we have a live debate at the moment going on issue of, at schooling level at least in Delhi and maybe all over the country, of providing reservation on economic considerations. You are saying there must be provision in each institution at the schooling level also of certain number of students who must be given reservation on normal fee payment. How do we look to catering to this segment of the society, our part of persons with disability, and say, look, here we must provide a certain percentage to them and assimilate them here. And how do we equip them? Because one of the major problems which arises every time, which is taken at the education level, is the institution is not equipped at the lower level to deal with children with this. We need specialized methodologies to deal with them, and we don't have it. So again, you go back to it, unless you have specialized assistances available in these institutions, the purpose would not be served by having these students as part of the institution. Because then the problem will be that how do you cater to their special requirements? So you go back to the special requirements. So even merely saying you reserve some part of the seat in educational institutions, starting from primary level, is not going to help till you create the infrastructure which is required to back it up. And say there will be certain number of teachers who are equipped to teach people with disabilities forming part of your education system. That, I feel, is something which should be done as a prerequisite before you introduce the requirement. And it will become a catch-22 situation otherwise. You will compel the students who join to leave because the education institution will not be able to take care of them. Now, we've had issues of some of them arising from, of course, the more general nature of drivers in the Daily Transport Corporation or other issues where judgments have been rendered, where they have said that look, you can't merely by holding the payment of compensation would be no ground to deny reinstatement to these people. You must give them reinstatement. What was happening is a lot of these people with disabilities, the corporation said, we will dispense with the services. We pay them compensation because of the disability suffered during the tenure of their service. But the chapter closes with that. The High Court said no, that's a separate, it's not mutually exclusive. So you must keep the job profile also open apart from giving compensation to it. Now, there have been certain circular directions of the university and directions issued by the High Court in respect of the procedures for recruitment which should be kept in mind while dealing with the faculties. And in one of the cases, in Shruti Kalra's case, the petitioner was disabled with congenital blindness. She approached the court and said that I cannot be interviewed at par with general candidates. It is again judicial intervention needed to come by and say that you cannot put them in the same category. The same procedure as you draw in a reservation system, draw a separate list, you must draw a separate list. You can't club them together with what is happening to the others. One of the other issues which has cropped up is the persons with disability. The question was compensation in lieu of future earning on the basis of income parameters. This issue came up, of course, in the Apex Court, which was considered in the High Court also, and I'm not delving into it in depth. One complete chapter would, of course, arise on the issue of mental disabilities. But I'm given to understand that's an issue which is going to be debated in the subsequent, and one of our other judges is speaking on that chapter separately. Therefore, what is that we are looking to and what is that we are supposed to do? I think mere judiciary has been active to it. I don't know whether it is active to the full extent it should be. It's a very debatable issue. But there has to be a multi-pronged action which has to take place. There are certain gaps which have been pointed out on the issue in the Act itself which have to be tackled. There is an issue of, I think, the more important aspect of how the executive and the officer level situation is to be tackled to at least ensure what is given is implemented. We are talking about how best to enlarge it. But the first question is what the entitlement is, at least that much must be given. The effort seems to be to rather see how not to give it rather than to give it. Therefore, the judicial interventions which have taken place are so far largely in the direction of ensuring that what is already provided in the Act, where action has to be taken, at least in those areas some mandamus can be issued to do so. As to how the Act has to further be modified, there have been some issues where the judiciary has intervened a little more actively and has come to a situation of construction which would enlarge the scope of it. But I think the first parameter is to see at least what is given is fully implemented. I would in the end only say that end with a quote which I read which is from part of the Holy Bible. It says, "Then the eyes of the blind shall be opened, and the ears of the deaf shall be unplugged. There shall be lame men to leap as a hart, and tongue of the dumb sing." We cannot do it actually, we can do it metaphorically. We can do it metaphorically because if we are able to provide the course of basic education coupled with employment to that, look to them as part of our own society, I think that job would be done in this process. Thank you.
Thank you, Justice Kaul. With that, we end this session. I thank Honorable Justice Shivraj Patil, Honorable Chief Justice A.P. Shah, Honorable Justice Vikramjit Sen, Honorable Justice Sanjay Kishan Kaul for the inspiring speeches, and Chief Justice Vinay Khan for gracing the dais. May I request everybody now to move for tea. The tea is served outside on the left side of the entrance. And can we be back in 15 minutes because we're running short of time? Thank you so much.
We are running a little behind time. We have two speakers in this session: Dr. Aloka Gua on the National Trust Act and Major General Cardozo on the Rehabilitation Council of India. Now, as you will notice in the structure of the program today, you will have a series of persons speaking to you of the problems faced by the disability sector. And you will get a feedback of the legal difficulties, the insurmountable problems faced at times by people in the disability sector when they come across the law. When they go to courts, when they go to their lawyers to file cases. And you will get, I think, a very frank and upfront series of perhaps grievances as to how the legal system is dealing with the disabled in our country. We'll start the second session with Dr. Aloka Gua, the chairperson of the National Trust.
Good afternoon, ladies and gentlemen. I find myself in a minority, not only because of my gender, but also because of my non-law background. And thirdly, because I am currently, temporary, but still, a bureaucrat. And I don't find that particular species is very popular in this room. So I'm going perhaps to be saying things which you may not appreciate, but I've been given a job to do, which is to speak about the National Trust Act. Can I have the lights dimmed, please? Is that possible? Thank you. In that, I have a little story to tell. It's about two children who were playing in the sand. One was a 10-year-old mentally retarded child, and one was an 8-year-old non-disabled boy. And this boy asked this girl, "Are you disabled?" And she says, "No, I'm Susie." This personness of people with disabilities, that has to be recognized first. We are no longer talking about pity, we are no longer talking about charity, we are no longer talking about welfare. We are talking of development, we are talking of rights, we are talking of empowerment. That is a paradigm shift. First paradigm shift. The second paradigm shift is when we have moved away from the medical model of disability into a social model. In the medical model, the doctor decided or the therapist decided what is best prescribed for the person with disability. In the social model, the person with disability and his family is at the core of all decisions that are taken for persons with disability. These two paradigm shifts are very important in our sector, and I wanted to share this with you. And this picture gives us what we are really looking for, that people with disabilities are very much in the mainstream programs with their non-disabled peers. We have 3 legislations in our country, as you know. The first was the Rehabilitation Council of India Act 1992, represented here by Major General E.N. Cardozo. The second was the Persons with Disabilities Act 1995, which was discussed earlier. And the third, and the least known, I'm afraid, is the National Trust Act, for the welfare of 4 categories of people with disabilities, and they are the least well known also, and that is autism, cerebral palsy, mental retardation, and multiple disabilities. 3 out of these 4 categories were not represented in the PD Act adequately, and so there was this feeling amongst parents and lobbyists and professionals, including myself, that we need a separate kind and a separate focus for these particularly severe groups of people with disabilities. The prevalence here, as you can see, we have 2 sources of data. We're no longer talking about 1/10 of the population, etc. We are talking 10% of the population. We're talking about much smaller figures. Whether these figures are right or wrong is not the question here. The point is that we finally have some degree of reliable data. One is the census, one is the NSSO, and we are talking somewhere between 1.8% to 2.15% of the general population. There may be a lot of underrepresentation, particularly with mental retardation, where parents are not willing to come forward and speak up and say, yes, I have a mentally retarded child. It is possible that has happened. But we are talking somewhere in the region of 2 to 3, 4%, not more than that. The rural disabled people are 3 times as much as those with urban disabilities, people with disabilities. And the good news is that there is definitely a lowering in the prevalence of disability, particularly with very good programs like the National Blindness Control Program, the Leprosy Mission, and the Polio Plus programs. There is very strong evidence that the disability rate is going down. But there are other disabilities which are being more recognized now. Take autism, for example. Have you heard of autism before? You didn't. But now we hear lots more about autism. We hear lots more about multiple disability. 19% of the disabled population have multiple disabilities. And you know, when you are deaf and blind, it's not that you're adding deafness to blindness. You're actually multiplying. The impact goes beyond the combination of the 2 disabilities. How do you teach a child who's blind and deaf? You teach a blind child through his hearing capacity. Teach a hearing impaired child through his reading capacity. How do you deal with a person who's both blind and deaf? And these are disabilities that are recognized more and more strongly and clearly in our sector today. The relationship between poverty and disability. Radhika mentioned it in the morning, and this has very, very strong consequence. Both cause and consequence, disability and poverty, are very closely related. The legislative framework that we have, as I mentioned, 3 different legislations. RCI, which then Cardozo will talk about, talks about human resource development and the registration, standardization of courses, etc. The Persons with Disabilities Act talks about non-discrimination, equality, positive measures, but also about grievance redressal. The National Trust Act talks about a much more caring, shelter, protection kind of act, because we're talking of people who might be very severely disabled and they may not so much fight for their rights as require protection and support services. This is the institutional framework that the Government of India has. The blue framework is the Ministry of Social Justice and Empowerment, headed by 2 ministers, one cabinet and one state. And we have a large number of proposed programs going on, including at the grassroots level. They're called district disability rehabilitation centers, over 100 of them. There are national institutes. There's a large funding for private organizations, NGOs from the Government of India. Then there's a Chief Commissioner's Office, which is completely independent, or should be. And then there are autonomous bodies. There is a National Handicap Finance and Development Corporation, which gives loans for disabled people at very, very small interest rates. Then there is the RCI, and then there is the National Trust Act. There is a whole structure, an institutional framework through which people with disabilities are supported. And similarly, at the state level there is, and at the other ministerial level, there is a lot of, or much more now than there used to be, a lot of interministerial convergence with railways, with finance, with DOPT, with urban development, rural development, education, etc. health. Some of these figures are quite mind-boggling, really. How many people have been trained? Doctors, over 18,000. Several 20 lakh children with disabilities have been identified for enrollment, of which 15 lakh disabled children are actually employed already. 25,000 professionals trained in the disability sector. There are 16 lakh teachers who have had short-term training in inclusive education. Look at these figures, they're very, very impressive. But only in terms of absolute numbers. When you take them in terms of percentage of people who deserve or who need to be supported, or the number of teachers we actually need, given that we are a population of 1 billion, then these figures don't seem quite so impressive. The National Trust Act was basically an answer, the government's answer to parents' question of what will happen to my child after I die. What are the issues here? When you have a blind child, when you have a physically handicapped child, of course parents are concerned. They're worried sick every day of their lives. But when you have a mentally retarded child, who is going to look after that child after the parents are gone? Brothers and sisters have moved away to America. The undivided family has broken up. So the concern of this parent, especially if they have a girl child with mental retardation, is enormous. It eats them up every day of their lives. So certain provisions are very specific, legal provisions to this particular category. We have a board which controls the National Trust, which has representations from 3 parents, 3 NGOs, and 3 people with disabilities themselves. This is really a unique kind of board. 2 people with multiple disabilities on our board, 1 person with cerebral palsy on our board. The people with multiple disabilities are both deaf and blind, and they have taken very important decisions on how the trust should be run. The differences with the PD Act, I'd just like to point out here. The disabilities served in the PD Act are 7. In the National Trust Act, there are only 4 categories. The orientation in the PD Act is rights. In the National Trust, I think it is more protection. The implementers in the PD Act are the state government. In the National Trust Act, it is the NGOs. The authority in the PD Act is the CCD and the state commissioners. And in the National Trust Act, it is an elected board, and that point is important, the elected board and through local level committees and NGOs. The Grant and Aid PD Act doesn't have. The National Trust has been provided with a 100 crore corpus, which helped us to start our programs. It's abysmally small, of course, and we need much, much more money, but it helped us take off, start the programs at whatever level we could. And of course, the main objectives are different in the 2 acts. The important objectives, we talked this morning, one of the Honourable Justices said that there aren't enough shelter homes, etc. Again, as a result of the paradigm shift that I mentioned in the morning, it is not our first priority. Building institutions, putting people away in them and throwing away the keys, that is no longer a first objective. The first objective is that people with disabilities should be empowered to live within their own communities, as part of the communities in which you and I live. You and I have a right to live with our families. Why should people with disabilities not have a right to live with their own families? No. Why should we separate them? So we must empower and strengthen the communities, change the communities to the extent that we absolutely can, mainstream them into community programs, starting from Balwadis when the child is 6 months or 1 year old, and ending with all social customs, social activities, etc., marriage, etc., etc. So that independent living and living within the community, social inclusion, is our first objective. Our second objective is to support organizations when there are families in crisis, when there are destitutes with disabilities, and when there are orphans. Of course we need institutions. Unlike the West, they're breaking away all the institutions, everything, all homes, institutions, bade buildings सब तोड़ के निकाल देते हैं. वो हमारे लिए possible नहीं है. We still need, because we have large numbers of people who are destitute, who are abandoned on the streets when parents sometimes find their child is disabled, they abandon them. Or they just leave the mother to deal with it. So for them, we will always need some number of institutions, and also because we have large numbers of very poor people for whom the strain of bringing up a disabled child is much more than if the family was economically stronger. So we will need institutions, but that is our second objective. And our very important objective here is to provide legal guardianship. This is the first time that legal guardianship because of disability is being provided, and I have with me our legal advisor, Mr. Gautam Banerjee. Questions on legal guardianship he will be able to answer. My next slide is about, can I have the next slide please? That's finished, yes. We do a lot of our work through video conferences, and questions come up in that, what are we going to do? Parents ask, what am I going to do with my child? What will I gain by getting legal guardianship? What will I gain by getting legal guardianship? I will explain that question later. We have a system. I want to explain to you the system that we have, which is registered organizations. We have stringent criteria for registering organizations. Over 1,800 applications have come. We have given only 639 so far. We have established institutions. We've been functioning for the last 5 years. We have established 113 institutions across the state, which is clearly too little, and we'll be able to have another 100 or so by next week. We've got a new grants committee going. This is the first time that we've got caregivers program where people at the grassroots level, including members of families, are trained within the community to serve disabled people at home. As I mentioned, we're talking about mentally retarded, autistic, cerebral palsy, otherwise sometimes you may refer to them as spastics. They have difficulty that other disabled people do not have. So for them, home-based education sometimes becomes very, very important, home-based rehabilitation. Yes, this is, you can see, caregivers training. Young group of children celebrating Christmas. This is in Himachal, in Una. Young people in Kolkata living in an independent living situation. That is the goal. How do people live within their own resources independently? What have we done here? We have supported them minimally. But these young people are living together in an independent living situation. Young man in a wheelchair is learning to cook. You know, Bengalis, we are very fond of begun bhaja, bengan fry. This young man is learning to fry his own bengans. And how does he do it? Because the shelf of the kitchen counter has been lowered to suit a wheelchair user. I'm talking of a very simplification of a system, but it has much broader implications that we need accessible and barrier-free environments for people with different disabilities. Supported guardianship is a scheme that we have started. 500 rupees a month is given to 10 people in selected districts who are at the intersection of poverty and disability. And if we had more funds, we would be able to upscale this to 580 districts across the country. Those who are both poor, very poor, and very severely disabled. They may not be able to find jobs on their own. They may not have any other means of economic survival. They would need a form of social security to be provided by the government. State nodal agency centers. In every state we have a state nodal agency center. My appeal to all of you is, please access our website. If you need help before you make any judgments, before you make any decisions, please access our state nodal agency centers and ask them for information. Reliable, valuable, appropriate and relevant information will be available to them at their fingertips. A lot of training programs we have. Major Cardozo will talk about them later. This is an institutional framework that is available to the National Trust. A local level committee constituted statutorily under Section 13 of the National Trust Act. It has a DM, a district magistrate or a district collector as the head of the organization. The second member is a disabled person himself. This is the first time that a statutory decision-making role has been given in such a good capacity to a disabled person in the community. The third person is an NGO. So 2/3 go to the private sector, 1/3 only to the government. Their role is giving legal guardianship as per Section 14 of the National Trust Act. These are some of the activities of the local level committee, how they're going to do, where they're going to do. They have the authority to give legal guardianship, and they have to decide. This is the first time that legal guardianship is being given on the basis of disability. Others are always on the basis of minority. Now, you might say, why do we give legal guardianship? You and I, when we become 18, we become majors. We get our driving license, we get open our bank accounts. But people with mental retardation, their physical age and their mental age may not match. So even when they're 18 years of age chronologically, their mental age may only be 2 or 3 or 4 or 5. So they may not be able to make informed decisions about themselves, about their finances, etc. So we provide for legal guardianship to be given through the local level committee within 45 days. I'll skip and I'll go to the next slide. These are some of the local level committees formed across the country, over 400 of them. 218 of them are active, and I would like to see some. Our Act doesn't have any punitive measures, unfortunately. Perhaps you can advise us on how we should go about that. So many district collectors are too busy with other things, not looking at this issue, and therefore only 218 of them, 20 actually, are active. Legal guardianships, tremendous resistance. Time district collector doesn't have. Reason parents find, why should I do this, why should I not do that? So up to now we have approximately 5,000 legal guardianships given only, which is absolutely peanuts. We need to create much more awareness on this. This is the legal guardianship statutory requirement, Section 14 of the National Trust Act. A parent of a person with disability or his relative may make an application to the local level committee for appointment of any person of his choice to act as a guardian. It could, of course, be the parent himself or herself, and it's only for persons with autism, cerebral palsy, mental retardation, multiple disabilities, not any other disability. And the reasons why you need a legal guardian, etc., because for this category, the informed decision making is not always possible, and they need assisted decision making only if they need it. The choice is there. Types of guardianship. One is for the person. Now, if you have a mental retarded person who is physically absolutely able, he goes to the toilet, he manages, he travels on his own, he holds down a small job, but you give him money, he can't handle it. You ask him to do something that requires abstract thinking, he can't handle it. So for that person, you need a guardian for his property. Whereas you get a person with cerebral palsy, who actually legs and hands are very difficult, all over the place, but mentally he's absolutely bright. So he can handle his property, but he can't handle his own person. So 2 types of guardianships are offered here. And the kinds of guardianships, this is something you know very well about, I won't go into this. Next. Some districts have done remarkably well, and one particular district has brought out a book. Can I go to the next slide, please? Brought out a book. I mean, she made the whole district disability friendly, making sure that every child, every person with disability has some benefits. Just go through this quickly. Yes. Under the government of India, there are schemes for pension, there are schemes for housing, there are schemes for self-help groups, there are schemes for vocational training. What we need to do is to ensure that disabled people get integrated, get mainstream into existing programs. Horizontal inclusion without creating too many vertical programs, and we can and we do. There is 3% reservation for disabled people in all poverty alleviation programs. We just have to ensure that this is followed. Some districts do it, but a majority don't. Please go ahead. This is houses built under Indira Awas Yojana. No money spent by the district collector, just converging issues, converging programs that are already there. And then she brought out a book which is every district collectors, we are circulating to them, and some of them actually follow it very well. It's What can we do to ensure the rights of disabled people? I hope the judiciary brings out a book something like this. What can the judiciary do to ensure the rights of people with disabilities? You will notice it's written by a DM. She doesn't talk about charity, she talks about rights. So these are all issues that we need to discuss. What are the problems that we face? Problems faced by persons with disability in accessing services. First is that there's an information vacuum. How can we solve that? With much more public awareness. We need lots of public awareness in a massive way. Physical barriers, both transport, roads, buildings. The government is now giving 10 lakhs to each district to make barrier-free features within the existing buildings. Most people don't, most districts have not used this. There are distance barriers. So we need to have much more programs coming to the district level, taluk level, etc. A percolation of services. Inappropriateness of services, that is a major, sometimes you have 18-year-old kids sitting in special schools doing building blocks, for heaven's sake. I mean, they've outgrown that maybe 10 years ago. So a lot of inappropriate services are given because there is a lack of services. When there are financial constraints, there's a lack of caregivers, and there's, of course, finally, absence of services. The next slide is about what are the problems that the government faces. The government are basically 4 M's. The money part, the manpower part, the material part, and the mindset part. Absolutely, maybe we work backwards, start with mindset, and everything else then changes. So we need to change attitudes to a very large extent. Then, of course, there are lack of good NGOs in rural areas. Then there's a low profile of persons with disabilities, and the resultantly low priority for government officials. They're not very visible. People with physical disabilities, people with orthopedic disabilities, they stand outside their door, they stand outside the DM's door, and they create a halla, they go on watchers, they do this and that, and they are heard. They are listened to. But people with other disabilities, in the mental retardation and other severe disabilities, not only do they not represent themselves, their parents are so burdened with just day-to-day survival, they do not appropriately represent their children either. I will say that even then, there are interstate and intrastate variations. Some states are 20 years ahead in the types of work that they do, and some states are way behind. I'd like to end here with a little story. It's about a time when there were people who had to carry water from the stream and take them to people's houses. There was no running water. So there was this pot bearer with 2 pots. He would fill up the water at the stream and carry 2 pots of water to his master's house every day. One pot had a little hole in it, and he was very ashamed of himself, very depressed. One day he picked up the courage to tell his pot bearer, "Sir, I'm sorry, I have a hole in my side, and because of my hole, you are losing water every day. You take the trouble of filling up 2 pots of water, but you only deliver 1.5. It's because of my hole in my side. I'm sorry." The pot bearer said, "Fine, I'll take you up this path without water." He did that, and he said to the pot, "Now look out of your hole and you tell me what you see." So this pot looked out of its hole and he said, "I see flowers." And the pot bearer said, "See, I always knew that you had a hole, and that is why I have planted seeds only on this side of the road, so that water from your plant can leak out every day and water these seeds, and along with 1.5 pots of water, I also deliver a fresh bunch of flowers to my Lord." Thank you so much.
Speech.
Any questions on legal guardianship? My legal advisor has to do it.
If there are any questions on legal guardianship, which I may not be able to answer adequately coming from such eminent people, I would like you to ask these questions to Mr. Banerjee while he is here. He has to leave, he has a flight to catch. So if there are any questions on legal guardianship, can we have them now, please? No questions. Thank you. Sure. in the previous, the first session also there was a discussion about, whether or not persons with mental disabilities and psychological impairments are covered under the provision for employment for them. Since you interact largely with that group of people, if not psychologically, but the intellectually disabled people under your purview, so with your interaction, have you ever heard this, or has somebody ever made out a case for asserting that right to work or employment guarantee under the Disabilities Act? Because I look at Act not only the employment provision limited to Section 33 of the Act, which has been widely referred to in the previous session also, but there is Article 40 and 40, Sections 40 and 42 of the Act equally important, which talk about promoting employment of persons with disability to the tune of 5% actually in the private and public sector, which is linked to government's formulation of a scheme by which incentive could be offered to private and public sector. And I know my question is becoming long, but I want to come to this point because we don't have that experience in India, in a very organized experience in India of placing people with disabilities in the private sector. But in many countries of the world, Ms. Abua, you visited and known, the system of quota and levies exist. Even in our neighboring country of Pakistan, the private sector is brought under the obligation of providing reservation to such sections, and then those systems are functioning, and then the concepts of supported employment for persons with mental retardation are in operation in many places. So have ever the parents made out a case asserting the benefit of employment under those provisions of the Act, if not Section 33, which has imposed some sort of limitations there, restricting it to only 3 categories of the disabled?
Anuradha, thank you so much for a very important issue that you raised, and I would seek suggestions from the floor. This is the most crucial, the most limiting aspect of this disability, intellectual disability, mental retardation, autism. It's impossible to find good jobs for them. It's impossible to get them placement in public and private sector. We do not have reservations for them under any of the acts, and it is also now our endeavor to get parents together to lobby for a reservation for this particular category. We've not been able to do it yet. The only employment they get is through self-employment, through loans from NHFDC, through self-help groups. I was amazed. I was in East Khasi Hills maybe 2 weeks ago. Jen and I were there together, and I went to this remote village in Meghalaya. There was no electricity there also, but this group had been able to come together, mentally retired,
and some of their families.
Forming a self-help group, they've accessed 1 crore from the Ministry of Rural Development. They were so amazed that they got that project that they didn't know what to do with the money to begin with. They ultimately organized themselves. But at this point in time, the employment opportunity for persons with these disabilities is largely through poverty alleviation programs or through self-employment, getting loans. I know of mentally retarded people. One guy, there's one girl, mentally retarded girl that I knew. She had difficulties at home. The parents would give her, maybe she had no father. Mother would give her 1 cup of rice a day. Brother used to treat her like a servant, make her do all the housework, etc. Then one day, we gave her a loan. I used to work with an NGO at that time. We gave her a loan, and she started making idlis. So she started making 40, 50 idlis. They were so good. People in the village stopped making idlis in their own houses. They'd come and have breakfast with her. Ultimately now, she makes 400 to 500 idlis every morning. She employs her brother, she employs her mother, she employs her sister-in-law, and she's like the head of the family now. The kind of achievement she has made simply through economic independence. But this is an issue that I would like your suggestions and advice on.
My question is, will it not be perilous to provide job to persons suffering from schizophrenia?
Sir, we are talking here only at this point. My authority is to expertise is in the field of mental retardation as against mental illness. So Anuradha's question was of course much broader, but I have very little knowledge about that field. My concern, my mandate is largely for the intellectually disabled. The mentally ill will be, that section will be discussed. I think in the afternoon there is on the Mental Health Act there is a section. My concern, I've listened to all of you in the morning, and you're all talking about physically disabled. You're all talking about the blind with people with disabilities. There's questions of people with severe disabilities, question of women with disabilities, question of children and senior citizens with disabilities. These are all important questions we need to ask, need to find out from you. How can we help? How can we together make some amendments and some concerns by which this group can be helped?
It was told to us that local level committees are not functioning properly because collectors are too busy. Is there any proposal to change the constitution of these committees?
That will come to it. What I have done so far in the last 4.5 years is to travel from district to district to district, sensitizing collectors, training them. I put them in wheelchairs and I put them on crutches and I say, go to the second floor and get your disability certificate. Then they learn what it is. I make them blindfolded and I give them, here's lunch, eat it. At 9 o'clock you have rice, at 3 o'clock you have dal, etc., etc. So that is, I thought, let us try by persuasion first, by training, by sensitization, and that way we will be able to get 220 of them functioning. But then time will come when we will have to look at other mechanisms for making the local level committee more functional. That's our research project with NHRC. That's why Anuradha brought it up, that looking at the efficacy of getting a central legislation implemented at the district level, particularly with the DF who sits on 200 committees, and each committee has to meet at least 4 times a year.
Can we move on to the next?
Anuradha, can I try to answer the question? I'll just try to answer this question. It's a personal view. Anuradha's question with regard to employment for the mentally challenged. Now there are 3 types of employment. There's open employment, there's sheltered employment, and there's self-employment. Open employment, we all understand, outside. Sheltered employment is what NGOs, parents, professionals give to persons who are disabled who cannot work outside. And self-employment is self-explanatory. Now, I am personally of the opinion that as far as persons who are disabled are concerned, if they have to apply for a job, they should be capable of carrying out the duties of their job. As far as, and therefore, if a person is locomotively disabled, he's lost a hand, or he's lost a leg, or he's polio, or whatever, there are job descriptions which match their disability. It's easy to decide as to what they can do and what they cannot do. But as far as the mentally challenged is concerned, this is the major area of the problem here. How do you decide as to what a person who is mentally challenged can do or cannot do? Because each individual is different from another. And therefore, I feel a project or a study needs to be carried out, what I would like to call capacity index. You take the broader categories of mentally challenged persons, whether it is autism, whether it is MR, whether it is CP, whether it is mental illness or schizophrenia as was brought out, and then carry out a detailed study of various types of individuals and then try to work out a capacity index. It has not been done anywhere in the world. It has been done in bits and pieces, but some sort of comprehensive capacity index needs to be worked out, and that is, in my opinion, a possible solution to helping persons who are mentally challenged from accessing jobs. Thank you.
Okay, thank you, Mrs. Guha. And she has to leave for
Just one question to General Cardozo.
Yeah, if he is going to speak,
Just 1 minute, because he has answered the question put by the lady. Now, in providing job to a person who suffers from some kind of disability or physically challenged person, are you also required to take into consideration the compensation that he has received for the disability that he has suffered? Are you required to make distinction between two classes, one who is physically challenged otherwise, or who has incurred disability subsequently for which he has been compensated?
No. Simple answer is no.
Why not?
I'll tell you why. I am a person who has lost a leg in the 1971 war. I get a disability allowance. If I work anywhere else, do you think that I should not get the compensation for my being disabled?
See, if suppose you incur disability in an accident for which you are compensated by the court on the ground that you have suffered a particular percentage of disability for which you should be compensated, so to that extent you stand compensated. How is it that you claim once over for the extent for which you already stand compensated?
So if I understand your question correctly, if I have lost a leg or a hand due to the work that I am doing, and you compensate me for it, and after that, I continue to do a job and to do a job well, do you mean to say that the compensation should not be given to me?
See, Mike, I'm not clear, it seems.
No,
I'll give you an example. Now, suppose a person is going on a road. He is knocked down by a vehicle, and he suffers a disability. The disability is assessed by the court. Let us say 20%, 30%, and assessing it as a loss of income. His income is assessed, and to that extent he is compensated. Now, in getting a job, are we not to take into account that he is to be treated like an able-bodied person for the purposes of the job under the Act? Now, are we not to take into account the compensation which he has already received to the extent of the disability?
In my opinion, no.
The disability should be on the natural disability or a disability caused by some accident or otherwise.
Irrespective, if a